Pretrial adjudication. Voluntary dismissal. Plaintiff may voluntarily dismiss her case either with or without court approval. Dismissal will be without prejudice, so plaintiff can bring claims again unless an exception applies. Dismissal without leave of court allowed before defendant serves an answer or motion for summary judgment. Plaintiff voluntarily dismisses by filing a written notice of dismissal or stipulation signed by all parties who have appeared. Dismissal is without prejudice provided that the first time that plaintiff has dismissed her case, otherwise it is with prejudice. Dismissal with leave of court. This is required if there have been an answer motion or prior dismissal. Court has discretion to grant dismissal on terms and conditions it deems proper. Dismissal is prejudice unless it states otherwise. Pending counterclaim. If defendant has filed a counterclaim, plaintiff cannot voluntarily dismiss without defendant's consent. Default judgment against defendant may be entered when defendant fails to plead or otherwise defend a properly served complaint. Procedure. Plaintiff files motion for default judgment against defendant. Clerk enters default on docket. If plaintiff shows that defendant failed to respond within 25 days of being served, 60 days if service waived. Default does not automatically entitle plaintiff to recovery. Clerk or judge must enter judgment of default. Default judgment by court clerk may be entered if 1. Defendant has not responded at all, 2. Claim is for monetary damages, 3. Plaintiff gives an affidavit of sums owed, and 4. Defendant is not a minor or incompetent. Default judgment by court. If elements are not met, court may still enter a default judgment and hold a hearing on damages. Defendant may be entitled to a hearing if defendant has appeared at some point in response to plaintiff's complaint. Defendant must get 7 days notice of a hearing on default motion. Recovery is limited to the amount demanded in complaint. Setting aside a default judgment. A court may set aside default judgment for a good cause shown within 1 year, usually satisfied if defendant can show executable neglect, mistake, or fraud. Failure to state a claim and motion for judgment on the pleadings. Under Rule 12, defendant may move to dismiss for failure to state a claim or move for judgment on the pleading due to plaintiff's failure to bring a plausible claim. Defendant arguing that even assuming all allegations in plaintiff's complaints or pleadings are true, plaintiff cannot win. If granted, plaintiff will usually be given leave to amend her complaint. Failure to state a claim versus motion for judgment on the pleading. Timing of filing. Before defendant files answer, Rule 12b6 motion to dismiss. After defendant files an answer, Rule 12c motion for judgment on the pleadings. Materials reviewed by court. Rule 12b6 motion, court reviews sufficiency of plaintiff's complaint alone. Rule 12c motion, court reviews all pleadings. Summary judgment. So either party can file a motion for summary judgment asking the court to enter judgment. It must be filed no later than 30 days after the close of discovery. The burden is for the moving party. They must show 1, that there is no genuine dispute of material fact, and 2, the moving party is entitled to judgment as a matter of law. So there's no reasonable person could find for a moving party. The motion is based on pleadings and evidence submitted. Burden shifting. If the party moves for summary judgment, the burden shifts to non-moving party to show that tribal issues exist. The non-moving party must submit requests for more time to take discovery. Must specify discovery sought and how it will help. Then there's evidence examined in the light most favorable to non-moving party. A court can look at the whole record of admissible evidence. Note, this distinguishes motion for summary judgment rule 12B or 12C motions in which the court may only look at the complaint or pleadings. Partial summary judgment. Court can grant summary judgment on only certain claims. Alternative dispute and resolution and settlement. Federal courts must have alternative dispute resolution program, and the FRCP actively encourages settlement through various means, including mandatory settlement conferences. The alternative dispute resolution generally refers to the means of settling disputes outside the courtroom, including arbitration and mediation. Mandatory settlement conference is a court-appointed advisor. It meets with parties privately and offers evaluation of the weaknesses of their respective cases. Settlement offers. A party defending a claim may make a formal settlement offer at least 14 days before the date set for trial. Settlement for less than the offer. If claimant rejects settlement offer and obtains judgment less favorable than the unaccepted offer, claimant must pay costs incurred by the offering party after the offer was made. Ordinarily, costs do not include attorney's fees. The exception involves litigation in situations where federal free shifting statutes define fees to be part of the costs.